Today marks a dark day for peaceful environmental protest, the protection of environmental defenders, and indeed anyone concerned with the exercise of their fundamental freedoms in the United Kingdom of Great Britain and Northern Ireland. Today at Southwark Crown Court, Mr. Daniel Shaw was sentenced to 4 years in prison for his involvement in peaceful environmental protest. This follows 2 requests I have made to the government of the United Kingdom to respect Mr. Shaw's rights under the Aarhus Convention and international human rights law. First, in my letter of allegation of 12th of March 2024, and second in my public statement of 24th of June 2024 at the start of Mr. Shaw and his co-defendant's criminal trial. It also follows my decision to personally attend the trial of Mr. Shaw on 4th and 5th of July 2024 in light of my grave concerns regarding the potential outcome of the trial for Mr. Shaw personally, as well as anyone considering joining peaceful protest in the United Kingdom in the future. The gravity of today's sentencing decision becomes glaringly obvious when considering the act for which Mr. Shaw has been sentenced. Mr. Shaw participated in a Zoom call that discussed climate change and the organising of a peaceful environmental protest. This is the factual basis for Mr. Shaw's conviction and sentence for conspiracy to cause a public nuisance. Put differently, today's ruling by Mr. Judge Hare at Southwark Crown Court means that in the United Kingdom, participation in a Zoom call that discusses peaceful protest, in Mr. Shaw's case, to call for an end to the continued issuance of oil and gas licenses in the UK, exposes the participants of the call to the risk of a lengthy prison sentence. How a sentence of this magnitude can be either reasonable, proportional, or serve a legitimate public purpose is beyond comprehension. As I have repeatedly reminded the United Kingdom, it is, however, precisely these criteria that need to be met to show that a sanction imposed on an environmental defender like Mr. Shaw does not amount to penalisation in violation of Article 3.8 of the Aarhus Convention. Mr. Shaw's 4-year sentence falls strikingly short of meeting this standard. Importantly, this sentence comes after 113 days in prison on remand that Mr. Shaw has already served, and the draconian bail conditions which he was subjected to for over 1.5 years while awaiting trial. Measures which on their own may amount to penalisation in violation of Article 3.8 of the Aarhus Convention, and already prompted me to raise concerns with the UK government in March this year. What happened to Mr. Shaw today is unacceptable, both from a legal and a societal standpoint. A young man has been sent to prison for 4 years due to his decision to come together with others to discuss how to prompt government action through entirely peaceful means to address the serious threats posed by the climate crisis. This sentence should shock the conscience of any member of the public. It should also put us all on high alert on the state of civic rights and freedoms in the UK. One must ask what comes next when an individual like Mr. Shaw, who sought to exercise his right to peacefully protest, to peacefully raise his concerns about the existential threats posed by the climate crisis and the failure of his own government to take adequate steps in response, is treated like a serious criminal and put behind bars for 4 years. Rulings like today's set a very dangerous precedent, not just for environmental protest, but for any form of peaceful protest that may, at one point or another, not align with the interests of the government of the day. Given the gravity of the situation, I urge the new United Kingdom government, with absolute urgency and without delay, to take all necessary steps to ensure that Mr. Shaw's sentence is reduced in line with the United Kingdom's obligations under the Aarhus Convention. I underline once again that prior to his conviction, Mr. Shaw already spent 113 days in a prison cell on remand for the same Zoom call, in itself a highly draconian and deeply questionable measure against someone who participated in a call on peaceful environmental protest. I will remain deeply engaged with Mr. Shaw's case until I see concrete action by the UK to protect Mr. Shaw's rights as an environmental defender. 18th July 2024.